Hi everybody, my name's Carol Saunders and I'm the Union Relationship Manager at Gordon Legal. Currently we're seeing a lot of disruption in workplaces and sadly that's extending to job losses. Today I've brought together our personal injury lawyer Jenny Forty and our employment law lawyer Fiona Rothgill to answer some common questions about workers' rights on termination, including where you might be on work cover or, if you're not sure, whether you have a right to make a work cover claim. So I'll introduce you to Jenny.
Hi Carol, thank you. Yes, we're hearing from many workers who are unsure where they stand in relation to work cover and who fear that they may have lost some rights to claim compensation under the work cover scheme because they've lost their job.
So Jenny, on that issue, can workers who have suffered injuries in the course of their employment still pursue compensation claims under work cover, even if they've been terminated or made redundant? And what type of compensation can they get?
Yeah, good question, Carol. Certainly, if a worker's lost their job or they've been made redundant, they can definitely still lodge a work cover claim. And if that work cover claim is accepted, then the injured worker may be entitled to compensation that generally fall within three categories. So firstly, medical expenses. So an injured worker is entitled to be reimbursed for any reasonable medical expenses that they've incurred to treat their injuries. That can include a GP visit, medication, or even surgery. The second category consists of weekly payments of compensation. So if an injured worker is unfit to perform the job that they were doing before they suffered their injury, then they are entitled to be paid a weekly payment. And thirdly, if an injured worker has suffered permanent injuries, then they might be entitled to pursue lump sum compensation for those injuries.
So Jenny, what is considered an injury at work?
Well, generally speaking, injuries at work fall within two categories. So there are those injuries that are suffered on a specific day whilst someone is present at work. So an example of that might be someone who is working on a job site and they trip on an exposed pipe and then they suffer injury to their knee, for example, as a result. And then there are those injuries that develop over time, usually because of the type of work that an injured worker has to do. So for example, someone might suffer a back injury because of years of repetitive manual handling, or someone might suffer a lung condition because of continuous exposure to chemicals.
And Fiona, I just want to go to you. So from an employment perspective, what are my rights if I'm terminated or made redundant?
Yeah, thanks, Carol, and hi, Jenny. In terms of if you're made redundant or terminated, you may still have rights to challenge the dismissal on grounds that it was unfair or it wasn't a genuine redundancy, or perhaps because you were terminated for an unlawful reason, such as you raised a workplace right or you made a complaint about your employment. There may also be cases now where employees raise concerns about the new JobKeeper scheme to their employer. You know, for example, an employer might be exploiting the scheme or not paying them the full amount that's owed. I think this will be a growing area, and I'd encourage workers to reach out and get advice, talk to their union, get some legal advice. There are significant new penalties for employers who do the wrong thing. If you're terminated, you'll usually be paid notice and, if applicable, redundancy pay. That's set by your contract or by your enterprise agreement, or otherwise the default is under the National Employment Standards in the Fair Work Act.
Okay. Fiona, what if the employer can't pay or afford to pay redundancy?
Yes, under the Fair Work Act, an employer can apply to the Fair Work Commission to reduce a redundancy pay that's due to an employee, including to none. That can occur where an employer finds acceptable alternative employment for an employee, or, as we may see more of, where they cannot afford to pay the amount due. Previous decisions of the Commission have made it clear that an exemption from paying is only granted in limited situations, and it's not granted just because it would be inconvenient or difficult for the employer. However, the current economic climate, we're likely to see more cases, and it's likely that the bar is going to be lowered. Employees should get advice and remember that there are commission processes that can be used to interrogate employer financial records if you want to get to the truth of the matter and make sure it's not just being put on. If an employer does go under, such as through liquidation or bankruptcy, and an employee loses their job because of that, There are also a national safety net scheme called the Fair Entitlement Guarantee Scheme, which may pay unpaid wages and also entitlements such as redundancy if the employer hasn't paid those.
Okay. Now, Jenny, I'll just quickly jump back to you. What about hearing loss? So I often speak to workers who've worked in lots of noisy environments over the course of their working life. I just wanted to ask, can they get compensation for their hearing loss?
Yes, they actually can. The law actually requires that a hearing loss claim be lodged against the last noisy employer in time. So that takes into account workers who may have been employed by different employers, all of whom expose them to industrial noise. And the entire compensation for someone's entire working life is all compensated by the single claim that is lodged against the last noisy employer in time. And Carol, that compensation can include the reasonable cost of hearing aids, as well as lump sum compensation in some circumstances if someone's hearing loss is permanent and is of a certain level.
When should injured workers speak to a lawyer after they've suffered an injury at work? What would be the timing for that?
Well, it goes without saying that the most important thing after someone has suffered an injury is for them to get medical assistance. But it is a good idea to get legal advice early because it's important for injured workers to be armed with the right information to allow them to maximise their compensation under the Workcover scheme. And secondly, there are some very strict time limits that apply to Workcover under the Workcover claim. So it's important that injured workers don't miss any of those.
Guys, thank you so much to you both for spending some time with us today. I just wanted to relay on to everybody out there that if you need any help, please reach out to your union, have a discussion with them, or get in contact with us. We're here to assist you through this difficult time. Reach out if you need to.